National Underwriting Counsel for Westcor. I'm actually glad that we're not talking about FinCEN. I probably was doing 3 FinCEN presentations a week. So when we got this opportunity, it wasn't FinCEN for me. It was an easy one because I don't have to talk about FinCEN. But in any event, I'm going to talk about the boundary line issue and understanding the de minimis standard. Hopefully take you through some title insurance considerations, take you through the case law, the history. Some of this might be repetitive for some of you. And as Diana mentioned, please ask questions as we go along. Because we're on a time here for credit, if I miss the questions, we can reserve that time at the end to try to answer those. If we run out of time, we can certainly do like a follow-up email back out with answers to questions that anybody would have. But, without further delay, I'm going to, hopefully without any technical difficulties too, I'm going to get started on the presentation. You already heard my bio. I've been in the business about 24 years doing underwriting for all levels and all types of, different things. So in any event, talking about adverse possession. So adverse possession, generally we talk about an out of possession definition, the relevance to real estate transactions. It means a portion of property that is not within the control of a particular owner. So somebody essentially taking ownership to property, not via some written documentation, but because they've possessed it or they're occupying it or doing something with it. So as I understand it with New York and reviewing the history here, there's been some flipping of the traditional criteria, and we'll talk through those. But I did want to start first too, just to kind of tie it into title insurance, because we are a title insurance underwriter. And obviously when you get to situations where you can't determine ownership of property, you're going to look to title companies to take the risk. So I wanted to kind of start outlining in the title policy and then maybe go through all the adverse possession criteria, some of the case law, some examples, and at the end, hopefully tie it up a little bit to make it relevant to title insurance too. But essentially, the standard title policy insures against loss or damage sustained or incurred by the insured by reason of a defect, lien, or encumbrance on title caused by an encroachment, an encumbrance, a variation, or some adverse, and there's the trigger word, adverse circumstance affecting title that would be disclosed by some sort of accurate survey of the property. And then Schedule B kind of takes away some coverage with some exceptions, says rights of tenants and persons in possession. The rationale of title companies to raise this exception is it stems from practical problems associated with the examination of title, that companies do not want to be held responsible for unknown persons who might be able to make a claim founded on an instrument which would not cross the examiner's path. So maybe it's not something in a written instrument and just somebody's staking a claim to it. That's why we, at the title level, always recommend surveys where possible to obtain those. What I would like to point out is in lieu of surveys, sometimes, and maybe not so much in New York, but maybe sometimes people rely on Google Maps because Google Maps is such a great tool these days to see certain things. But it's very important to understand that sometimes Google Maps might show a ingress or egress. And then when you get a survey, you understand that that ingress or egress route might be on someone else's property. So Google Maps is not necessarily a replacement for it, but this is exactly why we talk about, the importance of surveys on title policies, just to understand, one, what the coverage is on a standard title policy, and then what's taken away via Schedule B, which is really the rights or tenants of a person in possession. And that's where it hits to the heart of the presentation today, because it's somebody adversely taking that property. So, why is it relevant to clearing title? Adverse possession is rooted in the common law. It dates back, very long time, several centuries. It's back in those days. It was acceptable to acquire land not owned by another by mere, actually sword or blood. As time went on, it became a justification for acquiring property by adversely possessing it. It's prompted a productive use of property or a use it or lose it kind of mentality. New York courts, the elements, and talking through the elements, New York courts have repeatedly applied the elements since the early 1800s. Now, the elements listed on this particular slide incorporate some of the newer ones as well. But, originally it was, you had to demonstrate hostile and under a claim of right, actual, open and notorious, exclusive and continuous for a period of time. Originally, it was 20 years, and that was reduced in 1963 to 10 years. With the new, and we'll kind of talk through how the laws change and how it's applied to some cases, but with the new law, it's the new criteria are open, notorious, and hostile possession, exclusive and continuous possession, and some terminology has been added under a reasonable claim of right. So not just a claim of right to the property, but somebody having a reasonable belief that they've hostily taking over some property, that it was owned by somebody else, and acts which constitute notice or protection by a substantial enclosure for a period of 10 years or more. So the new rule has kind of added some layers to make it a little more difficult to the normal criteria of what was considered adverse possession. So important to kind of go through those criteria. We will talk a little bit more about them in subsequent slides, but it's just, where maybe before you could cultivate land and maintain it and mow it and just take care of it was good enough to establish adverse possession, but no longer is that the case. We'll talk through how they've identified that and created criteria that makes this a de minimis standard or some permissive use, and it doesn't necessarily add up to adverse possession. And we'll, kind of talk through that. But essentially, today, all 50 states, because I'm national, I'm just going to do this really quick and talk about all 50 states have some sort of adverse possession. New Jersey and Louisiana have the longest possession period, 30 years. Texas having one of the shortest, 3 years. In New York, much of the guidance in applying the principles of adverse possession has come from case law, despite the statutes. And I'm sorry, I just advanced the slide now. So this kind of gives you an overview of the different states and their different adverse possession years to establish adverse possession. Again, it's all over the board in terms of the number of years. And obviously in New York, now it's 10 years. That was moved from 20 years in 1963. So moving on to the next slide, just kind of talking about the statute in a little more detail and where it's changed. Some of the sections where it changed a little bit is under section 501, which now defines adverse possessor or someone who occupies the real property of another with or without knowledge of the other party's superior rights in a manner which would give, such other owner a cause of action for some ejectment. The most controversial new requirement is that the adverse possessor must have a reasonable basis for their belief that the property in question actually belongs to the adverse possessor. The revision changes the old common law requirement that the adverse possession must be under some claim of right and adds the requirement that the claim of right be reasonable, which of course is going to subject these, arguments to more litigation, because what is reasonable or adding the reasonable, person standard is very fact specific and can very much depend on the specific transaction at hand. Possession must be hostile with the claim of right. It was not until 1962 that the rule was amended to codify a description for hostile and actual. There must be a taking of land. In other words, did the possessor put up a fence, plant boxes, or a driveway, or create some sort of encroachment with or without knowledge that the land is not theirs? No permission or consent, and the courts have presumed hostility if all the other elements are met. But there was a rebuttable presumption by a showing of implied or express consent, permission, or cordial relationship discussed in some of the court cases. Was the taking actual, open, and notorious? The possessor usually cultivated the land as if it was his or hers. There was a substantial enclosure, if there was a fence but no gate, some sort of physical presence. And if there was a substantial enclosure but behind the fence is wooded or unable to be cultivated. Was the possession exclusive for at least a 10-year period? It starts when the possessor exercises dominion and control, continuous for 10 years. Tacking is a criteria or a method that, if nobody's familiar with tacking, it's essentially somebody could establish the adverse possession for continuous 10 years by tacking on to a prior ownership. For purposes of adverse possession, the requisite continuity of possession may be shown by combining the successive possessions of several persons between whom privity existed. The successive possessions of both of those in privity with each other, when combined, constitute one continuous adverse possession. The elements of adverse possession must have been present for the entire period as a combined 10 years. The tacking method was used pre-2008 and post-2008 as well to determine and establish the continuous 10-year requirement. But all of the elements, it's important to understand, all of the elements must be shown by clear and convincing evidence. Once the elements are met, you have title by adverse possession, not a right to commence some sort of declaratory judgment action. So important, again, to understand how the law has changed, how it went from kind of just the 5 elements, and it added maybe new layers into the elements of adverse possession in order to make it a little more difficult, make it a little bit harder to establish the rule by adding reasonableness and bringing some other things into the equation to make it a little bit harder. And that's sort of the way the law went. Let's see, go into the legislative. Hold on, I think we skipped a 5. So the case that really prompted the rule change or the legislative change is the Wallings, and if I'm pronouncing this correct, Prisbilo, a court case that was decided in 2006. Jeffrey and Kathleen Walling purchased 13 Butternut Hill Drive in Queensbury, New York in 1986. Starting in 1987, the Wallings deposited filled topsoil on the northerly side of Prisbilo's side yard, dug a trench, and installed 69 feet of PVC pipe to redirect water from eaves and downspouts, all of which were under Prisbilo's property. In addition, Wallings placed an underground dog wire fence, continuously mowed, graded, raked, and planted and weeded the location. So essentially, to give you a visual here, it's the 2 houses. They install pool, but then there's some vacant piece of property between them that is the area of dispute. Prisbilos purchased their property in 1989 and commenced construction of their home in 1991, which wasn't completed until 1994. In 2004, Prisbilos discovered the encroachments because they conducted a survey of their property. Wallings commenced to declare ownership by adverse possession, and Wallings admitted that they knew they did not own the property. So there's one element of the new law I'd like to kind of highlight there. They didn't realize, or they actually knew, they didn't own it at the time. Under the new law, you have to have a reasonable belief of ownership of the property, or that it was a hostile property. It was believed to be owned by somebody else. The Supreme Court, Warren County, on a motion to renew, denied the Wallings motion for summary judgment, finding that there is an issue of fact as to whether the Wallings knew from the beginning that they did not own the property. The court reasoned that knowledge would defeat the element of hostility. The Wallings appealed, and the appellate division reversed, finding that the knowledge of the possessor that he or she does not own the property is insufficient to defeat possession claim, an adverse possession claim where all the other elements have been satisfied. The Court of Appeals affirmed the appellate division. The proceeding was lobbied there, soon after the senator and sponsored a bill to overturn the court's decision. Of course, their representation found it unfair that the owner, could lose their property, even though the adverse possessor knew the property was not theirs. So the knowledge piece, a reasonable knowledge, wasn't a part of the original rule prior to 2008. And that's where, when the new law was passed and signed by Governor Patterson in 2008, it changed to add that reasonable requirement to the rule in order to establish that they had to have some, even if they had some knowledge. Today, it might have been defeated by the new rule being applied. Back then, it did not apply to that. And then also, another ruling prior to 2008 that kind of triggered things was the Robinson rule. If anyone's familiar with this case, it's where there was a seasonal canoe rental of about a 6 acre parcel tract. And on that parcel, they maintained it. They put a little bit of a structure. They dropped canoes in that location. And they only did it seasonally, right? It was a canoe drop on someone else's property. And then the neighbor that challenged the use of that property, the Robinsons actually succeeded on that one. And one of the things that the original owner, whose property was taken by this adverse possession, tried to challenge is it was seasonal and they weren't there all around, the whole time of the year. But the court disagreed with that and said essentially that, seasonal didn't eliminate the factors enough to determine that they didn't have adverse possession of that property. So with those two rulings, those two cases stand out as probably a trigger that prompted the new rule to change and go into add some different criteria for the 2008 amendments. So how did 2008 amendments change adverse possession? 501, section 501 was codified, a definition for an adverse possessor. Now the requirements of adverse possession are as follows. It's open, notorious, and hostile possession, exclusive and continuous for 10 years. The adverse possessor must show a reasonable basis for his or her belief that the property belongs to him or her, and acts which constitute notice of protection by some sort of substantial enclosure so that the owner would have reason to know about the improper occupancy and cultivation and improvements such as fences, hedges, shrubs are no longer the basis for showing open and notorious and hostile. Those were deemed to be de minimis encroachments of some sort and deemed permissive under the new rule. So did the statute fix the ails of the prior statute or create more questions? A lot of people feel it's created more questions and essentially creates more litigation. And the courts, some of the court cases would lead you to believe they haven't given clear direction or clear answers on it. Much of the case law following the change centered on the court's confusion about when does the new statute apply, on or after the effective date. In a case, Hartman versus Goldman, the Second Department applied the new law. May 2011, the Hartmans believed they owned a strip of land based upon a 1987 survey they obtained when they built their home. They installed a drainage system, a driveway, lights, planted shrubs, landscaped it. The appellate division affirmed the lower court's decision granting judgment to the defendants. The appellate division agreed that the Hartmans did not acquire the strip by adverse possession because their use of the land was de minimis and permissive under the new rules. Note that the Hartmans' claims ripened in 1997-98. They brought the action in 2009. Had the old statute been applied, the Hartmans would have been very happy because they would have been successful in their adverse possession claim. Only 2 months after deciding Hartman, the second department decided Hogan versus Kelly in applying the old law because their claim ripened in 2006. In 2011, the third department applied the old law, and in 2009, the fourth department, the lower court, used new statute and denied adverse possession. The appellate court reversed and claimed it ripened prior to the amendment. And in Franza versus Olin, Franza cultivated property for 30 years. He mowed it, landscaped it, erected a shed on it. The lower court deemed these acts to be de minimis under the new statute. In the appellate division, where title has vested by adverse possession, it may not be disturbed retroactively by newly enacted legislation. This was the new issue raised in Franza. The application of the new statute would yield a different result from the prior law, would effectively be taking a person's right of way. So you can see there is definitely some change in the way the court's interpreting things and how they applied the statutes. But essentially, the new rule strengthens or layers the adverse possession requirements with a claim of right. Again, a reasonable belief of ownership. Sorry about that. And hostility. So hostility has to be more than de minimis, whereas previously it would be cultivating, maybe maintaining, mowing, and just taking care of property. In the new rules, that is not the case. And now you have to go a little bit further. So breaking down the new law, where it's most significant, and some of the most significant changes are under Section 501, it defines the adverse possessor as a person, entity who occupies real property of another person or an entity with or without knowledge of the superior's ownership rights in a manner that would give the owner a cause of action for ejectment. 512 provides that an adverse possessor gains title upon expiration of a statute of limitations where the occupancy has been adverse under a claim of right, open, notorious, continuous, exclusive, and actual. And 5013 was where the big change occurred. Claim of right as a reasonable basis for the belief that the property belongs to the adverse possessor or a property owner, as the case may be, and a claim of right as so defined is now required to establish adverse possession with some reasonable belief behind it. The land is deemed to have been possessed and occupied for adverse possession purposes by an adverse possessor where there have been acts sufficiently open to put a reasonable, diligent owner on notice, or where the land has been protected by some substantial enclosure. And then further into the revised statute, Section 543, one of the most significant changes, another significant change, I'd say, they've added the de minimis non-structural encroachments. So it provides that the existence of de minimis non-structural encroachments, including but not limited to fences, hedges, shrubbery, plantings, shed, non-structural walls, shall be deemed to be permissive and non-adverse. Although the term de minimis is not really defined under the statute, it just gives some examples. So again, along with the reasonableness standard that has now been added for the claim of right and the reasonable belief, which is up for debate and often a litigated area, so is de minimis too, in order to prove what is what constitutes real adverse possession. So under 543.2, it also makes permissive and non-adverse acts of lawn mowing or similar maintenance across the boundary line of an adjoining landowner's property. So to establish adverse possession under a written instrument, judgment, or judgment under Section 511, the occupant must prove that he or she or those under whom the occupant claims entered into possession of the premises under a claim of right. So again, the law adds some significant language or subtle language, the way you want to look at it, and it makes the adverse possession more stringent. It added the claim of right or reasonable belief of ownership, and it added to the hostility factor as well to make more than de minimis, more than permissive, and some substantial structure, and maybe more so than just mere fencing or something else. So, the law focused on those sections, most notably Section 501, 512, 522, and 543, and it just puts more pressure to prove adverse possession, not just incidental. So the bottom line, if a party establishes the adverse possession elements, but no claim of right, then they likely could lose their argument for adverse possession on a particular property. So used to say you could cultivate or just improve property, but that has been removed and replaced with acts that would put a reasonable owner on notice. So not just something incidental that somebody might not pick up on. And again, another change is the enclosure requirement and added de minimis section. So I think we have another example here. Yeah. So the one case that was, done almost immediately after the new law was, was pretty significant, was Becker versus Murtaugh. So this was the boardwalk and deck case that I would say. So Becker's owned some property that was on the beach area, and they built a deck and a boardwalk on property, later found out to be the neighbors, but they allowed certain people to use the property. And this focused on hostility, particularly came to light in this. But essentially, they allowed neighbors and contiguous property, but not the general public, to use the deck and the boardwalk. And essentially, the case, the way it came out, if title vests by adverse possession before the effective date, again, this highlights what law applies before the effective date of the 2008 amendment, then the old rule would normally apply. And it also highlighted the situation that allowing others to use the property did not negate the exclusivity element of adverse possession. So it essentially said, it's still exclusive, even if they let limited people use the property. Like they said, they let limited neighbors use it, but not the general public. So hostile does not mean hostility necessarily. And under a rebuttable presumption where cooperation between parties, because the neighbor whose property it ended up being on eventually got a survey, but they for years just were cooperating and using it, that did not necessarily make it non-hostile. So again, it's a matter of where the law is applied and what factors are done. But again, cooperation between neighbors doesn't necessarily negate the hostility portion of it. And just when the rule applies, that's what this case seemed to highlight more so than some of the others. And this was after the 2008. So, Becker did not permit the Murtaughs to use the dock or boardwalk, and Becker commenced suit. The Court of Appeals reversed the decision of the appellate division and awarded Becker title by adverse possession, using the old statute, opining that 2008 amendments were not applicable to the instant appeal because the Becker's title vested, and this action was instituted before the effective date of the amendments. So moving on. to another example of a city, and I know there's different criteria for some of the city-owned properties. So essentially, adverse possession of New York State and a municipality under CPLR Section 211C provides for 20-year statute of limitations period for an action by the state to recover real property. The state will not sue a person for or with respect to real property or the rents of profits thereof by reason of right of title, of the state to the same, unless the cause of action accrued or the state or those from whom it claims have received the rents and profits of the real property or some part thereof within 20 years after the commencement of the action. So I just wanted to point out there's a different standard on municipalities and what adverse possession is under the rules. The land which is held by a municipality in its proprietary capacity is not immune from adverse possession. Municipalities cannot lose title through adverse possession to property which it owns in its governmental capacity or property which has been made inalienable by statute. Assuming county took title to a lot in a tax proceeding, the county could hold a lot in its proprietary capacity and its title could be divested by adverse possession, where county never used a lot for any purpose and always intended it would be sold to somebody. So, wanted to make note of that, but let's take through this example here, which is not necessarily a municipality one, but it's just a example of some city type property in an adverse possession. So trying to apply what we know, this is a story about two contiguous parcels of property in the city. Parcel A is a 70 by 25 foot, is currently owned by A LLC and purchased it in 2002. A LLC purchased the parcel from a prior owner who owned it since 1998. Parcel B is currently owned by an individual, a member of B LLC. B LLC acquired its interest in 2005 and shortly after conveyed the property to individual B. About a year after individual B acquired her interest in parcel B, she advised A LLC that she wants to move the wrought iron fence as it was on her property. A LLC refused to allow, the removal of the same. In the dead of the night, individual B removed the fence. So essentially, what standard applies, because it occurred, prior to the 2008, the 2008 change in the law. How do we find out information about what's going on with the property and the extent of the encroachment and adverse possession? This is where we, gather up old surveys, old title reports, old deeds, maybe prior closing attorneys were involved in it, and prior owners. But it would appear that the old standard could apply here and does not require the possessor knows of the owner's superior interest. So as long as the prior owner did not take action, with respect to the AP ownership of the property. So again, trying to look at some of the application of the law and understand, different criteria under the different cases that come up. Another case that is pretty important, Lorenz versus Soares. This is a claim of right case where there was a chain link fence on particular property. This highlights sort of the permissive and non-adverse criteria under the new law. The plaintiffs owned real property. The Lorenz owned real property, which their backyard is adjacent to 3 different properties. There was a chain link fence that ran along the southern part of the Soares property. They're the defendants. And northern portion of the Lorenz property, the plaintiffs. The Lorenz brought quiet title action to establish ownership of the strip of the land. Approximately 800 feet was the encroachment. trees and shrubbery in front of the fence were present. The Lorenz never discussed the strip with prior owners before Soares. Lorenz planted trees on the disputed property. Lorenz moved the fence back toward their property when they installed a pool. So that's important to understand, to see if they move the structure, they move the fence back towards their own property. Maybe they didn't have knowledge that they actually own that particular piece of property. The defendants, the Soares, argued that, tried to make an argue on the zoning aspect of it, because each of the plots had to be approximately 15,000 square feet in size. And if they took away that 800 feet, theirs was roughly about 15,180 some feet, they might be out of zoning, and that could create an issue too. So, the claim of right was not established by way. The defendants never acquiesced in the establishment of the chain link fence. The Soares asked the company installing even the new fence to move it back toward their property a little bit. This was significant because this somewhat proved that neither party really knew where the property boundary was. Again, when the Lorenz installed their pool, they moved the fence because they didn't have a fence around their pool and they were required to do so. They moved the fence closer to their pool. The Soares asking the company installing the fence to move it back toward their property. So clearly, between the plaintiff and the defendant, they didn't really realize where their properties began and end. So there really wasn't an adverse event there. And then essentially the plaintiffs could not establish the 10-year statutory period either, because they didn't have consistent ownership of that particular piece of property. So again, another case that's illustrating kind of the struggle of the rule, or highlighting some of the different cases that try to interpret things and try to apply the rule a little bit differently. And it just kind of shows you why we have some problems, and maybe the legislation really didn't make this stuff clear enough for courts, and the courts trying to decide it, how it's very fact driven, and why title companies are looking at these different scenarios. And when you bring something to the title company about de minimis type encroachments or encroachments of every nature, why it's a little bit of a struggle, because there's really not a whole lot of clear, concise action as far as where things were decided or not decided in the courts. So moving on to the next slide. So for boundary purposes and boundary line variances, whether you're in the city or you're in rural areas, it's important because you want to know which statute to apply, depending on when a particular adverse possession could have been considered settled in any way, shape, or form. So it's important to ask questions. How long has the fence been up? Who erected the fence? How is the relationship with the neighbor? Because that's always going to be important. Depending if you get some sort of agreement out, does the owner have access to his out of possession land? It's again, 2015 case, Warren versus Karras, in the second department, title granted to an adverse possessor because he erected the fence. Hostile, open, notorious, for a period of 10 years with a substantial enclosure. What's a substantial enclosure? Again, issues of fact. There's not necessarily guidance given in the cases about what's de minimis. It's distinguished from other cases as well, but the relationship to your neighbor is important, because oftentimes these adverse possession suits arise because neighbors don't see eye to eye or are somewhat antagonistic about encroachments on fences. So people are not always going to agree on the fences and the property and the use of the property, even though maybe it looks obvious that they've been trekking over that property or using a particular piece of property for a long time, or maybe there's a fence or encroachment on. So it's really important to understand, access. Again, the relationship with the neighbor is important. Who erected the fence? How long it's been there? Um, there's some tools we will use as underwriters to determine, whether we can take the risk on or how we can deal with these. A lot of times, if you have cooperation with your neighbor, you can overcome some of those. So a lot of times, there's a fence out of possession exception put into policies and commitments. The owner of the premises, for example, is described in Schedule A, may be out of possession of a strip of land having a max width of an undisclosed distance lying between said fence and, name your direction, easterly, westerly. Policy exceptions. They accept any loss or damage as a result of this, typically. And a lot of times this is done for certain exceptions that are 6 to 12 feet, maybe, or more, is when these exceptions are more critical. Under that, sometimes, title companies will take risks on that. With a loan policy, for example, we may be a little more lenient, but you always consult your underwriting counsel. And with owner's policy, we're probably not going to be as lenient as we are. But essentially, that exception is usually raised when a fence or other structure cuts off access to the property for anything a foot or greater. A boundary line agreement and a fence affidavit are two items that are used sometimes to insure over, for lack of a better reference, these particular boundary issues. A fence affidavit is more case by case and is not really the standard. A boundary line agreement gets recorded in order to remove the exception, and gets recorded against both properties. So essentially, the neighbors will agree to the discrepancy in the property, and they will sign an agreement, and it's going to get recorded against both properties. And remember, consent, permission, or cordial relationship rebuts the presumption of hostility. So, those are some ways that the title companies will agree to underwrite some things and maybe overcome some of those boundary disputes. But again, those criteria, if you have good neighbors and they're in cooperation with each other, and there's clear access and understanding the criteria of the of the adverse possession, is going to be helpful, and bring all that information to the title underwriter so that they can understand better and help maybe alleviate some of that. So, just kind of some general summaries. If a person takes possession of property, improves it, possesses it in a public manner, and continues to do so for an extended period of time, traditionally that person would be deemed to have acquired the property by adverse possession. The concept of adverse possession is well known throughout the United States. Traditionally, the possessor of property, which is not his or her own, has had to meet certain and specific criteria, to acquire ownership by adverse possession. The traditional elements, and traditional, because we'll talk about just summarize the 2008 ones again. The traditional elements were open, notorious and hostile possession, exclusive and continuous possession for traditionally 10 years, under a claim of right. And again, we highlighted the discrepancy between how the law changed, and we'll talk about that again as a summary point. Affirmative acts by a possessor, such as payment of real estate taxes, the making of substantial improvements, the maintenance of property. So prior to the 2008 amendments to the rule, you might have been able to get away with mowing lawns, putting up a fence, paying taxes, maintaining the property, but that obviously has changed the way the new rule is written. So when the property and true owner find that someone has been in possession of the property owner's land, the true property owner generally has an affirmative duty to take action to remove the possessor by commencing some sort of action in ejectment. Alternatively, having discovered the possessor's occupancy, the true owner can grant to the possessor permission to remain on the premises with the owner's consent. This has traditionally eliminated the claim for an open, notorious, and hostile possession. So the 2008 amendment brings, like we talked about, some confusion in discussing some of the cases. Obviously, that's even confused some of the courts. But in July, again, 2008, when Governor Patterson signed the law signed the amendment into law, many changes in the law were adopted over the objections of the New York State Bar Association and concerns from the Land Title Association. Under the new amendment, again, it's necessary to, identify the elements of adverse possession, and they've changed a little bit. So again, open, notorious, and hostile possession, that hasn't changed. But what is hostile? Again, the new law has shed light on hostile and created a de minimis exception. So maybe what was hostile prior to 2008 is not going to be hostile now. Maybe those are permissive sort of actions or de minimis actions. Second criteria, exclusive and continuous possession for a period of 10 years. And then this is the third criteria. The prior one was under a claim of right. And now with the new criteria, it's a reasonable claim of right on the part of the possessor. So the person possessing must have a reasonable understanding that they did not own that property and it was owned by somebody else. And that has to be established as a criteria. Whereas before, there could have been something incidental and the adverse possessor might have gotten title to the property that way. But under new law, the reasonableness standard is different and added to the structure. And establishing a reasonable claim of right will no doubt have some difficult circumstances where adverse possession had previously been presumed. For example, title insurers may now be hesitant to, clean up and insure over common title defects, including breaks in the chain of title that are more than 10 years old. It's going to make title companies hesitate a little bit on particular maybe estate issues, or common title defects in the chain that are more than 10 years old. Because again, it's when is the application of the new law apply and when doesn't it apply? And defective descriptions, for example, corrected more than 10 years ago. Maybe there's been some insuring over by title insurers in that regard, but maybe no more. Maybe they're going to consider and be more hesitant or want some more information before they just agree to insure over anything. So prior to the revised possession statute, insuring over these old defects had become commonplace. Now, title insurers must consider the possibility of some owner from the distant filing in an action to quiet title and claiming that the newly insured owner has not established some reasonable claim of right for a period of 10 years. This is where I would emphasize again, when we get these questions, or just to stay out of, potential harm's way on insurability, is surveys are important. That's why they're important to make sure that we understand exactly what is being insured. And if there's anything that looks like it could be an encroachment, it can get questioned and ferreted out. The newly insured record owner may have difficulty establishing a reasonable claim of right for a full 10-year period because the new owner must tack onto ownership period of all prior owners within a 10-year period, and all must have held title under a reasonable claim of right. So there's that vertical privity that you have to be cognizant of. And the new standard definitely kind of adds more depth, or for lack of a better reference, more challenges to essentially establish that claim of right, because you have to do it throughout the tacking period too, if the new law is going to apply. So again, this section, you know, focused and changed several significant sections in the application of the law is what's most important. But the bottom line, again, if the adverse possessor possession appears to be that if cannot prove that he had some reasonable basis to believe that he owns the possessed property, he potentially loses even if all the other elements of adverse possession are satisfied. There's great uncertainty regarding how this new statute can be interpreted. There's definitely some numerous different case laws that have tried to, but you could see they're very fact specific, and sometimes they've struggled with interpretation of it and trying to apply the right law depending on when the adverse right began and potentially when it was established. Survey updates again or survey stakeouts should be performed in the event of any uncertainty regarding the location of any improvement, whether it's a fence, recorded line, there's some shrubbery there's some other obstacle that maybe before looked pretty obvious to be a slam dunk for adverse possession purposes, no longer is going to be the case for adverse possession purposes. So really important to understand that and look at the property and bring it to your underwriter so that they can make a determination of, the exception, or if there's some out of possession issue that needs to be resolved, would be important to understand. So really the application of the amendments that signed in the law, it struggled. There's different cases like we talked about throughout the presentation. And I think it's just, important to bring the facts, gather up as much information as you can and bring them to the underwriters in order to, try to determine, for example, when the new law applies, when the old law applies, and what criteria you're going to have to discuss and identify. So are there any questions that are coming out, Diana, that I can minimize my screen?
Yeah, sure. There are a few questions. Do you want me to read them out to you?
Yeah, it'd probably be easier if you do that.
Okay. Do these adverse possession changes apply to easements by prescription?
That's a good question that I guess I would have to look at if there's any cases that identified it. We can probably follow up with that. But I mean, again, it's probably, I would think they're going to evaluate and look at the criteria for the prescription use and determine maybe whether there is any challenge to that maybe before was, a given, or maybe they didn't really pay attention to, but maybe with the new law, possibly. I don't know if any's actually examined that specific issue, but I could try to find a little bit more and we can, send an answer out to the group. But my guess would be just the way some of these cases have gone, potentially everything's up for some debate, depending on how they took the easement by prescription.
Sure. I have a question about a driveway. Would a portion of a driveway be or not be considered de minimis? Somebody was using a portion of a driveway.
I personally think it seems like it'd be de minimis. There was the one case, I don't know if I mentioned it or not, but there was that exact case where you had somebody put a driveway and a fence, some shrubbery against a vacant lot, and it was determined to be de minimis in that case. So again, I don't know if there's the challenge with some of the cases in the statute is it doesn't really give specific criteria of what is de minimis, what's not, and what's permissive. So I would say just a portion of the driveway in and of itself may not be considered adverse enough and potentially could be considered de minimis. But looking at it with all the other factors, I think it's important to kind of look at the factors all together and see how they all add up, and potentially that could help based on the other factors and what was known at the time with the other, but just the driveway portion in and of itself, I would say potentially, there's a risk that it would be looked at as de minimis and permissive and not trigger any sort of adverse possession claim by itself.
Sure. I have two more questions that are a little more specific. Is it okay for a homeowner to place a fence on the property line when the neighbor only has less than 2 feet of property on the other side, and it's causing issues with them opening up their doors and et cetera?
So the fence is causing issues with them opening up their doors?
They have to walk on the sidewalks to get through their door. They're unable to open a side door all the way. So the fence is on the property line and has less than 2 feet to the neighbor's property.
Yeah, I mean, it sounds like, potentially, I don't want to say and give guidance on it's okay to put the fence up. I mean, if it's on the actual property line and there's no dispute to that, I mean, it'd be important to look at a survey and make sure the fence is actually on the property line. But it almost sounds like potentially, is it a zoning issue as well? Is there have to be certain, amount of space left on any particular sort of encroachment or fence or some sort of barrier? So I guess if the question's asked, is it okay? I don't know if I want to say yes, it is, or no, it's not. Is it an encroachment that's going to create some issue? That's something we would look at as a title insurance company. But as far as is it permissible, that's probably something to consult, the right professional to determine if the fence is already up. To me, it sounds like it's a question or a debate about whether there's an encroachment and whether it creates any issue that way, if I'm understanding that question correctly.
Sure. A seller installed a portion of a fence 2 months ago that completed another portion of a fence. So now together, this fence runs from front to rear of property line, cutting off a strip varying from 1/2 foot to 1.5 feet. And title has declared this is an out of possession issue. Seller wants to solve with a fence affidavit, but that won't run with the land, and buyers will have to readdress when they sell. Seller refuses to solve with a recordable boundary line agreement. I also have a second question. This was sort of a statement, but then I have a follow-up question from someone else that says, what can be done if the neighbor refuses to sign a boundary line agreement on an out of possession?
Well, if they refuse to sign it, then it potentially could be litigated, right? Unless you find an insurance company to insure the transaction. But if it's a sale, I would think there's a known dispute between because neighbors can get ugly about stuff like that, right? So if there's some known dispute between the neighbors, they may end up being very controversial about it. So what seems like a small minor thing could turn into a pretty major thing. So if they refuse to sign it, obviously you can't make them sign it. You'd probably have to get some sort of litigation on it if it's that significant of an encroachment. If they're not willing to agree on how to address it. To the first question, though, about not running with the land, that's true. You would have to either sign a new boundary line agreement with the next party, or potentially, I suppose, if the parties are in agreement about it, maybe they quit claim a portion of that property to the new owner, so that you don't have that problem in the future. It just depends how you can sort of identify the strip or the encroachment and the significance of it. But again, this goes to the last slide. How long, has the fence been there? Who erected it? The relationship between the neighbors. And then again, if they're not going to cooperate and sign something, I mean, you can't really force their hand. You sort of have to just probably do it, unfortunately, in some litigious manner to get it resolved.
Okay, and two last quick questions. Will title omit an exception based on a de minimis issue?
So de minimis in width, like I mentioned, the 6 to 12 feet, anything beyond that number, not generally, we're not going to do that. So it's all going to be case by case. We're going to probably have to bring all the information to the underwriter and we would have to discuss that and see. So I don't think there's an upfront automatic yes every time or no, we never will. I think it's a case by case issue. And again, like I talked about earlier, sometimes with loan policies, and again, case by case, but sometimes with loan policies, there's more leniency because more has to happen for a loss on a loan policy. With an owner's policy, it's probably going to be more conservative or more strictly, resisted, if that makes sense.
Sure. And one last question. Is adverse possession against a co-owner still 20 years?
Mm-hmm. That's something I'll have to get back on. I don't know the answer to that question off the top of my head.
Sounds good. Okay. Those were the only questions in the Q&A box for now. I'll let you know if any more pop up.
Okay. And if there are any more that come up and they come up post this presentation, then certainly you're welcome to send them my way and we can blast out an email response to everybody, to get those so everyone understands what the question was and understands what the answer's for. And I'll get back to you on the two questions on the easement by prescription and the 20 years in the co-owner issue as well.
Great.
But essentially, that really concludes the presentation. I did leave a little time for questions if there are any other ones, but I do want to give the code for credit is judicial. And what I would like to do is just open the floor again. If there's any questions that people want to pop in last minute, sorry, I'm all over the place on that. I'll just kind of put it all together here in this last slide and go through that. And if questions come up after, we can answer them. But really, putting the presentation together, old law and new law applies, understanding when the old law can be applied. There was one case where the old law wouldn't have applied, but the attorneys consented to bringing it in. So gets a little tricky. You don't hear that often, but that potentially could be a way the old law comes in where the new law would apply. But just understanding when the old law applies and the new law applies. Boundary line agreements, any use or possession by myself and predecessors in title of the strip of land between the boundary line and the fence has been permissive, has not been exclusive, and has occurred only in the spirit of cooperation among the neighbors. So the boundary line agreement is really the standard to resolve these encroachments that are technically disputes. A fence affidavit is out there, but it's not really the standard. It's really a case-by-case use. So consult underwriting if you're not sure. And really important to ask questions about encroachments. They can be adverse. Possession claims, can be defeated, but it's important if you have any encroachment on your property, or if people get surveys and they see encroachments, question them, ask them, talk about them. Just don't assume, and don't assume for your clients, and tell your clients not to assume just because it looks like it's on their property, it's their actual property, because it could end up being a dispute at some point in time. So try to identify these issues early in the process and prior to the transaction, and then it's just going to make everyone's life a little bit easier and a little bit less litigious, hopefully, and get some agreement with the new parties and the new neighbors.
Okay.
So I don't know if there's any
one or two more quick questions.
Yeah.
Just breeze through them.
Yeah.
If you have an agreement regarding a fence as a license, will this do for non-hostility?
Licenses concern us because they're usually a specific period of time. They don't run with the land, just to the question that was asked earlier. So I would say I don't know that it would necessarily, one way or the other. We'd probably have to look at the whole facts of the transaction just to see, but licenses concern me generally speaking because they're more limited and they don't necessarily run with the land. So they don't, they can be pulled, they can be canceled. We'd have to probably review the license agreement too, to determine what the terms are, who it applies to, how it can be canceled, how it can be, terminated. So those are important too.
Are boundary line agreements effective on successor owners for both properties?
That's a good question. I'm under the understanding they're only between the current parties. If you were going to do, if you were going to do a boundary line agreement, they typically, I would think, only enforceable against the parties that actually sign them. But we could follow up if they're recorded against both. Do they run with the land? That's a question I can, clarify better and see how we deal with that on an underwriting basis.
Sure. If somebody has a fence that's more than a foot inside of their property line and it has been that way for more than 10 years, can they simply move it to the property line?
So it's their, well, they don't know it's their fence, correct? I don't know that they could. I don't know that they should. I think that can be potentially a problem because they don't know if they really own that property. Um, their neighbor might cause an issue with something like that. So I wouldn't recommend they just do it. I would recommend they consult and potentially could force litigation between the parties for something like that. So I would probably recommend they don't.
Sure. One last question having to do with title. As soon as it's raised in a survey reading as a variation, even if not raised as an out of possession, title won't cover any defense of that, correct?
Right, because normally the anything raised on the survey should go into the policy as an exception, and it would be an exclusion under the policy typically.
Great. I think that's all the questions we have for today.
Okay. Well, I appreciate everyone's time hanging in there. I know talking about statutes and cases can be a little bit, sleepy at times, but hopefully everyone got something out of it. And, Diana and team, thank you for giving me the opportunity to do the presentation.
Thanks so much for a great CLE, John. We appreciate it. And this afternoon, I will resend everyone the affirmation and the evaluation and the material. So don't worry about that. And by next week, everyone will have their certificates. Any questions, send me an email anytime, and we will see you next month. Thanks, everyone.